Good morning. Thank you very much for joining us today. So it's a quarterly legal update and compliance update for block managers, so specific to the block management sector. As usual, there is a disclaimer, so nothing today should be taken as or construed as official legal guidance or official guidance, legal advice or official guidance, and is for general information purposes only. And with that, I'd like to hand over to our guest to introduce herself. Hi, Cass. Could you possibly intro yourself?
Hello, good morning. Good morning, everybody. My name's Cassandra Zanelli. I am Solicitor and CEO at Property Management Legal Services. And thank you very much, Raj, for inviting me back for this quarter's legal and compliance update. It's great to be here. Thank you.
Thanks, Cass. And thank you everyone in the audience for giving up your time for this update. So in terms of the themes we're going to be running through is company law, case updates, fire safety, reform of ground rents, service charge recovery, and then into audience questions. But we're starting today with company law because in the last webinar we did, we had a wide range and a high volume of questions about company law principles, some of which were sort of covering the basics of company law, providing notices, keeping documents up to date and registers. Some were more complex and nuanced. And so we thought we'd really start with an intro to or a recap of basic principles of company law. And the intent here is to cover things that would be valuable to new joiners to the sector, as well as people with experience. And with that, I'd love to hand over to Cass. Could you possibly start with a basic intro, I would call it, on company law for block managers?
Absolutely, thank you. As you say, Raj, we've had quite a few questions come in, haven't we, wanting to cover the fundamentals in relation to company law. So for today's purposes, I thought that we would look at meetings and general meetings of the company, because a lot of the questions that we had last time were focused around meetings, probably driven by what we were talking about last time, which was how to hold meetings in lockdown, virtual meetings and hybrid meetings, that kind of thing. And when we talk about companies in our sector, so in the block management sector, we tend to be referring to private limited companies. And there are a range of different companies out there, from PLCs to traded companies to LLPs, a whole host of different types of company. But for our purposes, within our sector, the kind of company that we tend to be dealing with are private limited companies. And RMCs, or most RMCs, will be private limited companies. They may be limited by share capital, or they may be limited by guarantee, but they are our private limited companies. And where we're dealing with private limited companies, there are two types of meeting that a private limited company will hold. They will hold board meetings, which are meetings of the company directors, and they will hold general meetings, and those are meetings of members of the company. And we're used to, aren't we, talking about people wearing different hats. So an individual may be a leaseholder, so wear a leaseholder hat, and they may be a member of the RMC or the RTM company, so wear their member hat. They may also be a director of the company as well. So a variety of different hats that people wear. Purchasing hat stands is probably the way forward on that one. But when we talked last time, we talked about how meetings were being held in lockdown, including AGMs and including general meetings. So let's deal firstly with AGMs. So an AGM is an annual general meeting. And it's important, I think, to flag in relation to AGMs that there is no statutory requirement to hold an AGM. And there's been no statutory requirement to hold an AGM since the Companies Act of 2006. But everything always comes with a but, doesn't it? But just because there's no statutory requirement to hold an AGM means that you need to look at the memorandum and articles of association of your company, so the memonarts, as we call it for short. And your memonarts are your company's rule book. And your memonarts will tell you if there's a requirement for your company to hold an AGM. So even though there's no statutory requirement to hold an AGM, there might be a requirement in the memonarts of your company, RMCs, to hold an AGM. And if there is that requirement in your memonarts to hold an AGM, then you will need to hold an AGM. I'm sure that all of you know this, but the memonarts are available for companies at Companies House. When you go onto Companies House and search for your companies, it's normally the very first documents at the bottom of the pile on the, I think it's the filing tab that it comes under. So you'll be able to find them there. When you
Sure.
are downloading the memo notes for your company, it's important as well that you go through the rest of that filing history so that you can see whether any special resolutions have been passed that have amended your memo notes. So not only look at the original memo notes when the company was incorporated, but look and see whether there have been any special resolutions that have been passed that have amended those memo notes, because those special resolutions might have amended the requirement or introduced a requirement to hold an AGM. So for AGM purposes, read your memo notes. Rule 1. Any other company meeting, so a company meeting of the members that isn't an AGM, is a general meeting, so a GM. And general meetings are called in 2 ways. They're either called by the board, so the directors getting together, having a board meeting and passing a resolution to call a general meeting of the company, or on requisition of members of the company. So members of the company have a right to get together, having met a sufficient threshold, and require the company to call a general meeting. So they are the 2 ways in which a general meeting is called. And what will happen is that once the decision's been made, however it's been made, to call a general meeting, that notice of that general meeting will be sent to all members. Now, there's no prescribed form of notice that you have to send, but a notice has to contain certain information. So it has to contain, for example, the date, including the day of the week, and the time and the place of the meeting. It has to set out the general nature of the business to be dealt with at that meeting, although articles may say something different in relation to that. If you're intending to pass a special resolution, and some resolutions are special, then you have to set out in your notice of meeting the text of that resolution. If you don't do that, then it invalidates the resolution. So it's important, if you're passing special resolutions, that you set out the full text of that special resolution. Where we're dealing with ordinary resolutions, there's no need, no requirement to set out the full text, but some people do because it's good practice to do that. And also what you should be doing within your notices calling a general meeting is to put a statement in there telling members that they have rights to appoint a proxy, so to set out what those rights are. And you will either give that notice of general meeting in hard copy form, so you'll post it or you'll hand deliver it, or you'll give it in electronic form, email, fax, if any of you are still using fax these days. There are other ways as well, but for our purposes, with what we do, it tends to be post or email, doesn't it? Dealing with notice or the time period for general meetings. Sections 307 and 307A of Companies Act set out the statutory notice period. So we have notice periods under statute that are generally going to be 14 days if we're dealing with an AGM or a GM. But I said earlier that we have provisions in statute, but it's important to read the memo notes as well. It's important where we're dealing with notice of meeting and time period in which meetings should be called, that you read your memo notes as well, because your memo notes may set out different notice periods in relation to meetings. Your memo notes might say that you have to give 21 clear days rather than 14. They might say that you have to give 28 clear days. They might say that you have to give different notice depending on the resolutions that you want to pass. So it's important. I bang on about reading, understanding and implementing leases. I bang on as well about the importance of reading, understanding and implementing what's in your memo notes. And memo notes are a lot easier to read than leases, trust me. So it's important that you are reading your memo notes and that you're making sure you're calling meetings in accordance with the timeframes and the time periods that are given by your memo notes. What it's also important to remember when you're dealing with calling company meetings is this concept of clear days and clear days notice. So if you're going by what statute says, so it's 14 days notice, then the day on which you send the notice doesn't count for the purposes of calculating that 14 days, nor does the day on which the meeting is held. So there has to be 14 clear days in that intervening period, plus allowing those couple of days for postage as well and for delivery when you're sending it electronically. There will be Raj, I think there's an ebook that will be circulated to people following this webinar. Can't speak, sorry. And in that ebook, what we'll do is set out and give you an example of how that would work in practice. So if a notice is sent on the 1st of July, for example, when's the earliest date that meeting could be held? So that will hopefully help clarify any concerns that people have in relation to calculating that, because clear days notice can confuse people sometimes because of what you have to disregard, and then factor in the 48-hour deemed delivery as well. Yep. Watch out, another thing to watch out for is in relation to special notice, because sometimes depending on the resolution that you're intending to pass at the meeting, you need to give special notice. And I know that sometimes the general meetings that you are calling relate to the removal of directors. And the removal of directors is one of those things where you need to give special notice. So if you are calling a meeting either at the board direction or because you've received a Section 303 requisition and that requires you or the business to be transacted at that meeting is the removal of directors, then you need to give special notice. And that's 28 days or 28 clear days that has to be given between notice and the meeting. Hopefully, Raj,
absolutely brilliant from my perspective. Hopefully this was useful to the audience. I recognize that for a lot of people on the call, you will have known a lot of this, but hopefully the clear and succinct way in which it was explained was valuable. And for people who are relatively new to the sector, hopefully this has been valuable too. Just one sort of tip before we go on to the next bit is when you're looking at companies on Companies House, please pay attention to the company number. So there are lots of companies that are similarly named, and companies can change names, but a company number is the unique identifier. So when going to Companies House, I'd strongly encourage you to search by company number, taking it right back to your original instruction, because that way you'll make sure that you've got the right legal entity. The next topic on company law is how to and who can sign documents on behalf of companies, partnerships, LLPs, sole traders, because again, we had a flurry of questions on this from the last webinar, and in fact, the one before. So would you be happy to give us a one-on-one on who can validly sign documents, please?
Absolutely. There is a difference, isn't there, between a deed that requires execution, and the way in which a company executes a deed is set down by Section 44 of the Companies Act, and we'll look at that in a moment. So there's a difference between the requirements for execution of a deed and other forms of written contract. And in our world where we're talking about deeds, we're talking about things like deeds of variation. So if your lease refers to a first floor flat and actually on the plan it's coloured as a ground floor flat, something like that, then you would enter into a simple deed of variation to deal with that, or if it refers to the wrong parking space. I mean, I'm dealing with a lot of deeds of variation at the moment for transfers where lenders are looking to exclude Section 121 rights and 121 Law of Property Act. You probably started to come across those, or where lenders are looking to exclude Section 8 Housing Act, that kind of thing. So there's a flurry of deeds of variation that is coming through in our block management world. So deeds of variation are one example of a deed. Lease extensions, if you're dealing with lease extensions, so surrenders, regrants, and also share certificates. So on a daily basis, you're probably dealing with documents that need to be executed by a company. And Section 44 of the Companies Act is specific in relation to how a company goes about executing its documents. And it executes, or a company executes its documents in two ways, either by affixing its common seal. And I'm old enough to remember seals getting dusty at the back of cabinets. Raj is smiling because he can remember this as well, what you used to have, leather bound books for companies. Don't get that anymore. Most of things are done digitally these days. But if you do happen to have a company seal gathering dust at the back of your cupboards on your shelf somewhere, then that's one of the ways in which a company can execute documents, and that's by affixing its common seal. The other way in which a company executes documents is by signature on behalf of the company. And that's either by two authorised signatories or by a director in the presence of a witness. These are the ways in which you will typically be executing documents. You'll be executing documents by either two directors signing, by director and company secretary signing, or by director in presence of a witness who attests the director's signature. So those are the, essentially for our purposes, putting aside the common seal that you probably won't have anymore, those are the three ways in which a company is going to be executing documents. So two directors, director and co-sec, director in presence of a witness who attests the director's signature. Simples.
And I was just going to sort of add a gloss there, which is ensuring that people understand in which capacity they are signing. So my understanding is that various managing agents out there are asked to sign various documents or do so of their own volition without recognizing that they are not the directors of the company and therefore able to sign those documents. So just being very careful about that.
Absolutely.
Moving on then to partnerships, LLPs and sole traders, because again, we had various questions about them.
Do we have, I mean, in my world and experience, there's not really very many partnerships or LLPs. Most of what we would be dealing with be limited companies for RMCs and certainly for RTM
I
companies.
assume that the question was more in terms of managing agents who were constituted as partnerships or LLPs, perhaps signing their own documents and making sure they're doing so correctly.
Yeah, if we cover that off in the ebook that we send round to people, Raj, I think that would be, then we can show the various ways in which all types of company go about executing and entering into contracts.
And then the final piece of this is, so we've talked about the different types of meetings that can be held, the need to provide clear days notice. What clear days notice are, is how you constitute the period for service of notice and how that all varies and how documents are signed. The final thing is what happens if the rules are broken. So what are the potential offences under the Companies Act?
It's very naughty to break the rules. There are a raft of offences under the Companies Act. If you go on and download them, there are pages and pages full of different offences that can be committed by companies and by officers of the company who are in default. Lots and lots of them, and some of them I wanted to flag with you. There are some common ones and some common ones that you will touch, and there are other ones that offer PLCs and kind of those kind of companies that you're not going to touch or deal with. But the ones that I wanted to flag are firstly, failing to send a registrar or to send Companies House a copy of amended articles. So we've talked about your memonarts, and we said, didn't we, about looking on Companies House to see whether there's been any amendments to those memonarts. When you amend your memonarts, you pass a special resolution, and it's a requirement to notify Companies House within 15 days of that resolution being passed. If you don't do that, then you commit a criminal offence, and it's an offence committed by the company and every officer in default. So that's the first one. If you amend your articles, tell Companies House about it, otherwise it's an offence. The second one is that there is a requirement under section 113 for every company to keep a register of its members, and section 113 sets out certain things that have to be included within the register. So name, address, date they became a member, date they ceased to be a member, if they hold shares, the type and number of those shares. Simple stuff. It's a requirement for you to keep that register, both of your current members and also ceased members and those who ceased to be members over the last 10 years. If you don't do that, it's a criminal offence. So that's the second one. And the third one to flag with you is in relation to inspection of register of members. So people have a right to inspect the register of members if they have a proper purpose for wanting to inspect the register. If you fail to allow inspection or refuse inspection, then that's a criminal offence. So that's an important one. And we can perhaps look at later webinars, section 116, and making those kind of requests for inspection, because there's...
Sorry, just on that, Cass, are you seeing or have you come across people using any of these things vexatiously? So
I am coming across, and it's coming across my desk as well, increased requests for inspection of register of members. Yeah. So members of a company that are exercising their corporate rights to inspect that register. And as I say, that register contains some important information such as name and correspondence address of the members of the company. So those are happening. And if you get that request to inspect the register, you've got 5 working days to do something with it, i.e. either hand over the register, so allow inspection, or apply to the High Court for a no access order. And I've been involved in those kind of no access order applications. It's happening.
Yeah.
The next one to flag with you is a lot of these are register based. So we've talked about register of members. The next one to flag with you is the obligation to keep a register of directors. And if you're not keeping properly a register of directors, that's the criminal offence. Same thing for register of secretaries, and same thing for register of persons with significant control as well. So these company record keeping things, if you're not keeping your company records or keeping them properly, the criminal offences, it's important that you have your record keeping spick and span. And also, I suppose the final one to flag with you is in relation to minutes of meetings. I suspect that there's meetings going off that aren't necessarily minuted or minuted properly. They do need to be minuted and minuted properly. For example, with directors' meetings, you have to minute those, and those minutes have to be kept for at least 10 years after the meeting takes place. If you don't, it's a criminal offence. So please do make sure that you do a bit of a spring clean in relation to your company record keeping, and make sure that it is what it should be. If not, you're leaving the company and its officers open to commission of criminal offences, which none of us want.
Brilliant. Thank you so much. For everyone in the audience, would love 2 things from you. The first is, if you've got any questions, comments or insights, please do submit them via the Q&A. And the second is, at the end of the webinar, there'll be a really short survey. So this is the first time we've done a sort of primer, and then we're going to dive into the usual topics we cover. So the whole purpose of this series is to be as valuable and helpful to you as possible. And so getting some feedback on whether this new structure or change in structure with a primer session at the beginning is valuable, or whether you would prefer more technical insights or more on cases, whatever it is, please let us know. We're running these sessions quarterly, and we're going to iterate on them as we go. Moving on to the next section. So Astor and Chapman, would you like to give us a case update, please, Cass?
Yes. Can I start with Stain and Richmond? Astor and Chapman is one that people are probably already familiar with, which is the dispensation case. And it reminds us that dispensation isn't binary, so it isn't yes, no, that there can be shades of grey where you are applying for dispensation, because dispensation can be given on terms. And Astor Communities reminds us, as we've known since Dejan and Benson, but it reminds us that dispensation can be given on terms. So in Astor Communities, dispensation was granted, but it was dispensation that was conditional and on terms. Stain and Richmond is an upper tribunal case from the last few weeks or so, and it's all to do with service charge demands. I banged on in this webinar about the importance of reading, understanding and implementing the terms of your Memmonites. This is my opportunity to bang on about the importance of reading, understanding and implementing the terms of your leases, because Stain and Richmond is a cautionary tale where that didn't happen. What you had in Stain and Richmond is a standard form lease, nothing interesting or exciting about the lease. And the lease had a covenant on the part of the lessee to pay service charges. And that covenant said along the lines of to pay to the landlord a due proportion, provided that, and basically that not less than 1 month's notice had to be given in relation to that payment or contribution. So a leaseholder had an obligation to pay service charges, subject to not less than 1 month's notice being given of the payment that was required by them. I bet you can see where this is going, can't you? What happened is that in July 2015, landlord appointed a new managing agent to manage the block. On the 18th of August 2015, the agent wrote to the lessee, "Hi, I'm your no agent. Here's your service charge demand, and here's your service charge demand for the period 25th March 2015 to 24th March 2016. So we're a bit late in serving it, but I'm your new agent. We're now serving you with this service charge demand. And at the bottom of the service charge demand, it said in big capital letters, payment due 30 days after date of demand, arrears by return. So the demand sent in August 2015 gives 30 days to make payment. Bear in mind that the lease says not less than 1 month's notice in relation to payment of service charges. So the service charge demand wasn't paid. It happens, doesn't it? It happens from time to time that service charge demands aren't paid. And the landlord brought proceedings against the leaseholder for non-payment. Proceeding brought in county court, transferred to FTT. Again, that happens. And the FTT determined that the payment wasn't valid, that the demand wasn't valid, and accordingly that the service charges were not payable because it hadn't been a valid demand. Insufficient notice had been given. There hadn't been at least that 1 month's notice. It was 30 days. And it just so happened that in August there's 31 days. So the two issues on appeal for the upper tribunal was what does that clause actually require in relation to the form of a demand, and did that invoice that got sent in August 2015 satisfy those requirements? And the upper tribunal, unsurprisingly perhaps, agreed with the FTT and said that the demand didn't comply with the minimum requirements of that clause in the lease. The upper tribunal said that the lessee was entitled to receive not less than 1 month's notice of the sum demanded in order and before that liability takes effect. The upper tribunal put it like this. They said that the giving of notice or notices is a condition of liability, and it requires a particular step to be taken by the landlord to inform the tenant not only of the amount which must be paid, but the date by which it must be paid. The date must be not less than 1 month from the giving of the notice. If the condition is not satisfied, the sum is not payable. So the demand for payment arrived on the 19th of August, expired on the 18th September. That doesn't comply with the clause in the lease that says at least 1 month's notice must be given because it fell short by a day or two here, but it fell short. And the upper tribunal were quite strict in relation to this, saying that this is what the lease requires. You've not complied with the lease, therefore those service charges that are set out in that demand aren't payable. So this really is, I suppose, the opportunity for me to remind you all that you will have your processes, you will have, as managing agents or as RMCs that are self-managing, you will have your processes for dealing with the demanding of service charges. Please make sure that your processes accord with the specific requirements of your lease. So even though you have a process, make sure that you have tested that process against the requirements of your lease, that you have read your lease to see whether there are any quirks in your lease that mean you have to amend your process for that particular development or developments. Read, understand, and implement the terms of your lease. Have a look, see whether there are any notice periods in relation to liability to pay service charges, whether you have to give a certain period of time notice before that liability is triggered. Make sure that your demands therefore accord with that, and also make sure that you are looking at to see whether there are any other precursors to payment, and make sure that you are complying with those precursors. The example that I always give, it's a really daft example, so apologies if you've heard it before, is that if your lease says your service charges have to be demanded on pink paper with purple spots, then go and buy some pink paper with purple spots, because you've got to demand your service charges on pink paper with purple spots, otherwise they ain't payable. Read your leases, make sure that you're demanding in accordance with the leases. Don't be a cautionary tale like staying in Richmond, I think is the moral of that story.
Thank you very much. And I guess through this webinar series, I kind of feel like your tagline is increasingly becoming, read your lease, read your memonarts, and if you've still got a problem, give me a call.
Pretty much.
Which is very much the way this is going. I'm conscious that we've got questions coming in, and please do carry on submitting them. We're going to sort of whiz through the next few bits because they're slightly more speculative at the moment. But So the first is, are there any updates on the Fire Safety Act, and what should block managers do now to prepare?
Yes, last time we talked about the ping pong that was going on, didn't we, between Commons and the Lords in relation to Fire Safety Bill. And the Fire Safety Bill was introduced to clarify, really, to be a clarificatory bill to clarify certain aspects of the fire safety order. Unsurprisingly, there were various amendments that were suggested in relation to the fire safety bill, which focused on who pays for the remedial works. That was the real focus of those amendments. And there was a ping pong, wasn't there, between the Lords and the Commons in relation to amendments being proposed, rejected, proposed, rejected. You know what happened there. But what eventually the outcome of this is that on the 29th of April, the Fire Safety Act 2021 received royal assent. And as enacted, it does not contain any of those proposed amendments. So all of that ping-ponging that we had going on, so it doesn't contain any of the proposed amendments that would have prohibited the passing of costs and remediation costs onto leaseholders and tenants. So Fire Safety Act is enacted. It amends the Fire Safety Order 2005, and it clarifies certain things in relation to the Fire Safety Order. And we tend to talk about Fire Safety Acts in the probably the same sentences or same conversation that we're having about the Building Safety Bill. But what it's important to, I suppose, recognise is that the Fire Safety Act applies to premises or to any building containing 2 or more sets of domestic premises. So it probably is going to apply to your portfolio, and because you're going to be managing blocks that contain 2 or more sets of domestic premises. So Fire Safety Act applies across the board. Building Safety Bill, which we'll talk about in a moment, applies to buildings in scope. And those buildings in scope are the 18 metres and above, 7 stories, those kind of buildings. Fire Safety Act across the board, Building Safety Bill, buildings in scope. So have that distinction in mind when you're thinking about these 2 acts or bills. One's an act, one's a bill. So Fire Safety Act, as I say, clarifies certain aspects of the fire safety order in relation to the building structure and external walls, and any common parts, including the doors between domestic premises and common areas. So your flat front doors, which I know lots of people have issues with. Although it has received royal assent and been enacted, there are parts of it that aren't yet in force. There is various guidance and regulations that will be coming out in due course, and those guidance and regulations will bring into force the sections of the Fire Safety Act. So it's been enacted, sections aren't yet in force, they will be brought into force in due course. So I suppose the moral with the Fire Safety Act as it stands at the moment is to watch this space. There will be lots of activity over the forthcoming weeks and months, both in relation to Fire Safety Act and also in relation to Building Safety Bill. So it's important that you keep up to date with what's going on there so that you know when things are being brought into force and what the impact of those things are.
Brilliant. And there's been what I'm describing as a relatively recent update to the guidance from RICS about the EWS1. And I guess this is a very tough question because it's never out of the trade press nor the national press. But I guess as a high level, what do you think that the changing guidance means for leaseholders seeking to sell or remortgage?
Gosh, I hear things anecdotally that this is the issue, that the guidance has been issued and that it's came into force back, I think it was the 5th of April that the new RICS guidance came into force because of that widespread concern that there was about mortgage lenders wanting EWS, frankly, on more than what perhaps EWS was intended or EWS1 was intended to cover. So a wider range of properties than had been intended or had been thought. What I'm still hearing, though, is that a lot of lenders are saying, well, it's our lending criteria. We want an EWS1 in relation to this building. We're not going to lend against it without. And there is still those challenges and those difficulties there, which seem to be lender driven, depending on what the lender's requirements are. And obviously the lender's requirements then have a knock-on effect, because the surveyor that's coming out or trying to do the valuation is saying, well, I need an EWS1 in order to be able to do this valuation. It has been acknowledged. I think Clive Betts, back last month now, so a couple of weeks ago, has been posing some questions around this and saying that the system simply, the EWS1 system simply isn't working, that there's the industry guidance that set out what buildings do and don't need the form, but there are lenders that are ignoring it and are opting not to provide finance without an EWS1. So I think he's written to government highlighting those concerns, has asked government what it intends to do to support the RICS guidance and to ensure that mortgage lenders adhere to the criteria that's set down in that RICS guidance. He requested, I understand, in his letter, a response by the end of May. As far as I'm aware, that response hasn't been forthcoming yet. So it's recognised, guys, that you are facing and still are facing challenges in relation to requests for EWS1s, notwithstanding the RICS guidance may well say that that building shouldn't and doesn't need an EWS1.
And with the amounts of, I guess, mainstream press, so this isn't an industry problem, it's a societal problem. And in national press, this is rarely out of the headlines, as I'm sure you're aware. So hopefully that level of political pressure will lead to an outcome. I'd just like to flag that as part of the follow-up email to this, you're all going to receive a link to an EWS guide that we co-wrote with Cass, or I suspect Cass wrote most of it. So that will be coming out to you. Just moving on to the next couple of points. So talking about the future of the sector, it seems that the government is determined to bring through the Leasehold Reform ground rent bill in this session of Parliament. What should managing agents be doing now to prepare, if anything?
It is. The bill was announced in the Queen's speech. It's perhaps no surprise, is it, because we've been talking about this issue of ground rents and, forgive the colloquial, doing away with ground rents for a number of years now. So no surprise that we've got the bill through. The bill is going through Parliament at the moment. I think it had its first reading back in a few weeks ago, back on the 12th of May. What the bill does in its current incarnation is that it will restrict ground rents on newly established long residential leaseholds to one peppercorn, so zero financial value, and so one peppercorn a year. It also, in its current format, will prohibit the charging of administration charges in relation to those peppercorn rents. So you can't get that income stream via the back door, as it were. It's a zero ground rent and prohibition in relation to the charging of admin charges in relation to those peppercorn rents. And it's going to apply subject to some exceptions to leases granted on or after the commencement date of the relevant provision of the bill. So it's not in force yet. It's something that is coming down the track. There's going to be certain types of leases that are exempted. So business leases, community-led housing, those kind of things. And there are going to be, I understand, special rules in relation to shared ownership leases. So it's watch this space in relation to that. It does introduce some civil offences with penalties as well if there are a breach, or if there is a breach of those restrictions, and a duty on trading standards to enforce it.
I've got a horrible follow-up question on that, I'm afraid, which
Okay.
is so it takes effect for new leaseholds, the leases that are granted after the date on which the Act takes effect. I presume that would also capture anything that would be deemed surrender and regrants. And so you may end up, if you are extending the premises of a lease, say including airspace or something else that wasn't previously there, ending up with one flat within the block being, with the ground rent being reduced to a peppercorn. Have I understood that correctly?
You have, yeah, absolutely. In that the bill, I suppose the mischief that the bill is intended to capture will also apply to surrenders and regrants.
Yeah.
So yeah, and variations of lease as well, because I'm on my soapbox now. Some people do lease extensions by variation, but they're deemed surrenders and regrant because you're extending the term. So yes, they would apply to those as well.
Okay, and just jumping again, so there's quite a lot to cover off on a quarterly basis in the sector. So, what does the Common Hold Council mean for the sector?
Yes, we have a Common Hold Council. Yeah, so a few weeks ago, everything's happened in May, hasn't it? May has been a busy month for the sector. So back in January, I think it was, MHCLG talked about plans to reform residential leasehold, and it indicated as part of that it would establish this Common Hold Council. And then a few weeks ago, 13th May, we had the announcement that it launched its Common Hold Council. And there are a number of industry representatives and groups within that Common Hold Council, Leasehold Knowledge Partnership, National Leasehold Campaign, British Property Federation, IRPM are one of those. Armour aren't part of the Common Hold Council. You may have read Armour's position in relation to that. In addition to the membership of the council, there's also a technical support group, and that technical support group is there to offer kind of legal and analytical expertise to the council. And the technical support group has Leasehold Advisory Service. It's got members of the Law Commission on there, so it's got some real industry experts who are going to help from a technical point of view guide the Common Hold Council. And one of the tasks that the Common Hold Council have is to provide advice on how to support Common Hold owners on taking on responsibilities for their building. And this is all, I suppose, part of the government's aim that it wants to take forward the Law Commission's recommendations, that the Common Hold system should be simplified, that the use of Common Hold should be expanded for both new buildings, so stuff that has yet to be built, but also for existing leasehold buildings as well. So this is one to watch to see how this Common Hold Council takes this forward, and what MHCLG do once they have the Common Hold Council's recommendations and reports. Watch this space.
I'm about to show my age. I remember when I was studying undergraduate law, and sort of 2002, Common Hold being the great new shiny thing, and studying it didn't feel like, well, it definitely didn't get traction. This time it feels like there's impetus, but whether it gets traction or not, I'm unsure. Moving on to the next.
You have now made me feel really old. I was in practice in 2002. Long since stopped studying. Thank you, Rod.
Sorry, Cass. So moving on to the next section. Sorry. So service charge recovery. The breathing space requirements, so including the mental health breathing space, I believe is the right terminology. What should managing agents be doing, or specifically not doing, in order to be able to validly claim arrears?
Yeah, so as I say, May, really busy month. One of the things that was busy in May was the introduction of these, the debt respite scheme. It's got a really long, complicated name, but for our purposes, let's call it the debt respite scheme. That came into force on the 4th of May. And what it does is that the debt respite scheme offers a number of protections, legal protections for debtors who are in problem debts. And the debt respite scheme gives them legal protections from their creditors. And service charge arrears, are one of those debts that could be wrapped up into a breathing space. So what happens is that if a person is having problem debts, that they will go and see an advisor, and if the advisor accepts that there are problem debts, then they will enter into a breathing space. Two types of breathing space. There's a standard breathing space, and that lasts for 60 days. And there's a mental health crisis breathing space, and that breathing space lasts so long as the mental health crisis does, plus 30 days. So that could be 6 months, depending on how long the mental health crisis is ongoing for. And the effect of this is that if somebody is in a breathing space, then creditor action is barred for the period of time that they are in that breathing space. So creditor action can't be taken. So steps can't be taken to enforce those debts that are wrapped up into the problem debts that are wrapped up into that breathing space. So you can't take action, you can't take court proceedings, You can't continue with any court proceedings that have been issued. So there's a moratorium. You can't keep racking up admin fees, and you can't keep applying interest. Everything is frozen whilst that breathing space is ongoing. Once the breathing space comes to an end, then the action can be restarted, those court proceedings can continue, and you can start to, from when the breathing space ends, start to reapply interest and start to reapply any admin fees or any legal fees if you've gone legal with it. So the first thing is to recognize that this exists and that you probably will receive a notification at some point that one of your lessees has entered into a breathing space, whether that be a standard or mental health crisis breathing space. The first thing that you need to do when you get that notification is check what debts you're told about compared to the debts that you might have on your system and see if those match. If there are any additional debts that you have on your system that you've not been told about, then tell the advisor about those additional debts. You then need to make sure that you have flagged your system in some way to make sure that you're not then chasing the lessee for those arrears that are wrapped up into that problem debt. You can't take any action against them. You can't pursue them for those arrears. You need to stop any action that you would be taking. And you also, if you have gone legal with any of these arrears, you need to tell your solicitors or your debt collection agent, however it is that you go legal with your stuff, you need to tell them that you've had this notification through about this debtor entering into a breathing space. And you need to, as I say, stop all action, and your lawyers will stop all action whilst that breathing space is ongoing, freezing any admin fees, freezing interest. And then when the breathing space ends, that's when you can start or restart the action against the lessee. But there is that period of 60 days or longer if it's a mental health crisis breathing space, during which no action can be taken.
Could I ask you what I suspect is a relatively dumb question, because I suspect I've misunderstood, but maybe I haven't, worryingly. Would a mental health crisis breathing space, if so it's for the extent of that crisis plus 30 days, if that crisis were to continue in perpetuity or for an extended period of time, is there a cut-off point for it? Or is it, if the crisis itself, and I recognise it's the crisis rather than the underlying condition, were to last for 2 years, would it be 2 years plus 30 days?
Yeah,
Okay.
it doesn't, and it's the debts that exist at that time that are wrapped
Yes.
up into it. So service charges are a recurring obligation, and it may be that further service charges fall due, so you will send your demand for those further service charges that fall due, if any do fall due within that breathing space. Similarly, you will continue to communicate in relation to Section 20s if you're doing a Section 20, that kind of thing. There is the ability to appeal against the breathing space, so you can write to the advisor and ask them to reconsider or to abridge the breathing space. If the advisor doesn't do that, then you can go to the court and ask them to review matters as well. I can foresee reviews happening or people asking for reviews to happen where it's an RMC, we've got no money, we need to do a massive project of qualifying works, we need the cash to be able to do those works.
Yep.
Those kind of difficult circumstances.
Thank you. And as a reminder, and I guess a plea to everyone in the audience, so this is a new structure of webinar with what I describe as a primer around a specific area, and then sort of ad hoc topics that are relevant to the quarter just closed. If this is useful to you as a structure, or you have any feedback on it, please take 30 seconds at the end to provide feedback. We'd love to hear from you. And with that, I'm going to go into the questions, of which we have many, you'll be pleased to hear. My colleague Remy has done a phenomenal job of sort of consolidating them, so taking them in order. AGMs. What should we do when our client refuses to hold an AGM, but their articles of association require one?
Your client, by not complying with the articles, is leaving themselves open to challenge from the members. So encourage them in very strong terms to hold their AGM.
But it's the client's liability rather than yours, I guess.
Unless you're an officer of the company.
Agree, yeah.
It depends whether you're a co-sec or not. I know some agents are, some aren't.
The multiple hats in the hat stand again. So I should probably flick that onto the audience questions tab. The next is we talked about the requirement for minutes of directors' meetings to be kept. To what extent are they made available, or should they be made available to members for review?
They're minutes of directors' meetings, so they are for directors' eyes only, rather
Excellent.
than being open for members' eyes too.
So I think this has got a few words missing, so I'm going to sort of summarize it as best I can. When signing on behalf of the company in the capacity of a block manager, can we sign documents as effectively agents, so utility providers, or should the directors themselves sign that? So who ought to be signing contracts that are entered into by the company?
It depends. It goes back to the terms of agreement that you have with your clients as to whether under the terms of your management agreement, and hopefully you have a written management agreement that's for 12 months or less with your clients, that will tell you that agreement will guide, shape and inform what you can do, what you're authorised to do and what you're not authorised to do. So be guided by what's in your written management agreement that's for a term of 12 months or less.
A question has come in, which I think we've covered a few times previously, but if you'd be happy to sort of just give a couple of bullet points on virtual AGMs and EGMs. So what is the current position and what happens if the articles themselves specify that the meeting has to be held physically rather than virtually?
Yeah, we had the Corporate Insolvency Governance Act that came into force June, I think, of last year, that covered us for a period from March to the end of September, that said, if you need an AGM, you read that as the AGM needs to happen by the end of September, and virtual meetings are permitted, so that members didn't have a right to attend a meeting in any particular way or to participate in any particular way other than by voting, and you couldn't vote in any particular way either. So you had those protections. Those were extended from end of September until end of December, apart from for the AGM, kick it into the long grass date. And they were extended again from the end of December to the end of March. Given that we're supposed to be in lockdown, I expected that they would be extended again at the end of March, but what do I know? That didn't happen. So we are now back in a situation where we have Companies Act, where we have the company's memo notes that will guide us and tell us what can happen in relation to virtual meetings and in relation to hybrid meetings. Virtual meetings are much as we're doing today, where we all dial in from our different locations. Hybrid meetings are where you have a specific place that you meet, and then people can either meet for that meeting in that specific place, or they can dial in from wherever they are in the world. As the name suggests, it's a hybrid. There is a lot of discussion amongst practitioners at the moment in relation to what you've posted in your question about hybrid meetings or virtual meetings and whether we can continue to have them. The first thing that we lawyers are getting very excited about is Section 311 of Companies Act. And it's Section 311, we talked about it at the beginning of this, that says your notice of meeting has to set out the time, the date, and the place of the meeting. We're getting very excited about whether place has to be a physical place or whether it can be a virtual place. It's fun to be around lawyers, isn't it? We get really excited about this kind of thing. So there's lots of discussion at the moment about place and what the meaning of place is for the purposes of Section 311. That aside, a couple of different schools of thought in relation to this. It hasn't been tested by the courts, which is why you have the couple of different schools of thoughts, and government hasn't yet intervened, and despite being invited to do so. There's one school of thought that says unless your memo notes specifically prohibit hybrid meetings, that you can crack on and have a hybrid meeting. There's another school of thought that says unless your memo notes specifically enable hybrid meetings, that you shouldn't be having hybrid meetings. So it depends on your approach to risk and whether you want to go with the school of thought that says unless it's prohibited, we can do it, or with the school of thought that says unless it's allowed, we can't do it. Two different schools of thoughts. We've yet to be told which is the correct one.
Thank you. And there's a question which I suspect we're going to have to swerve as probably not being the right people to discuss it, but there was a question posed around the difficulty or increased difficulty in getting professional indemnity insurance. and specific carve-outs that are being put into various insurance policies around, I guess you can call it cladding or flammability of buildings. Rather than posing the question here, I'd sort of signpost you to Rob Mayo or others. Cass, I presume you're coming across people who are having increasing difficulty in procuring insurance, or at least procuring insurance without exclusions. What's your take on the current market?
Absolutely, it's difficult. It's difficult to procure buildings insurance, so for the buildings that we're living in, but also difficult for from a PI point of view as well, because of the combustibility exclusions that seem to be going around at the moment. So it's a difficult and it's a hardening market. I know, Raj, you've mentioned Rob Mayo there. I know Rob is working really quite hard to put some form of product package in place that would address that.
A couple of the questions are continuing to come in, and we've got 4 minutes. I'm going to try and whiz through 3 of them. The first is on the debt respite scheme. Who should notify us? So I think we're talking here about the mental health crisis breathing space. So is it incumbent on the person seeking relief to notify, or should inquiry be made? So what's the physical process there?
Option 3, you'll get notified by whoever has approved the debtor entering into the breathing space, whether it's a standard breathing space or whether it's a mental health crisis breathing space. So you'll get a notification through from that advisor that has approved that breathing space, and that's when I say you'll look at what debts you've got on your system compared to what you're told about and see whether the two things match.
Perfect. The next, I suspect, is a webinar in and of itself and may actually form the basis of a primer in a future webinar. So again, if you think this is interesting or useful to you, please put it in the comments. It's multifaceted. So who should register for the with the ICO, so the Information Commissioner's Office, and in which capacity as data controller, data processor? If you've got a couple of bullet points you would like to give on that, or we can sort of kick it into the next quarter's webinar.
Yeah, and the quick answer is that if you go onto the ICO website, they have a variety of checklists for organisations, and you can go through. It's an online checklist. Basically, you click in various boxes, yes or no, and you can go through that checklist. And I think it's about 8 or 10 questions. It's not the longest of checklists in the world. And once you get to the end of that checklist, you will have an indicative answer from ICO as to whether or not you're processing data, and therefore whether or not you should be registered. And it's not just about registration with ICO, but whether you should be registered with ICO, and also whether you should therefore be compliant with GDPR and Data Protection Act. And compliance, as I say, isn't just registration, it's the policies and procedures and everything else that sit around that. So having your purpose for processing, having your lawful basis for processing, communicating that to the outside world as to why you're processing their data, what you're processing, who you're sharing it with, etc. A webinar in itself.
Yeah, I think it is, not least because I suspect over time managing agents are going to be processing and capturing more special category data as they start to understand the people within the buildings and understand the risk mitigation steps. So you will have disability, age, infirmity, status increasingly on residents within buildings.
Indeed. And in just going back to what we were talking about with the debt respite regs, mental health crisis, special category data.
Final question for you is, and I suspect you're not going to be able to do very much on it, but is, are there any interesting cases coming up that you think we'll be talking about in the next quarterly update?
Oh, no, but there's some interesting cases coming up at the end of the year.
Okay.
So we have a Supreme Court case coming up at the end of the year that looks at the we're coming to the end of the webinar, I can say this now, the mess that got created with Gala Unity, and this kind of what happens to a pertinent property, who manages it, who recovers costs, etc. So there's a Supreme Court case coming up in November, I think it is, somewhere around the 10th, 11th November that's being heard. And my understanding as well, I think we've probably talked last time about the Aviva ground rent case, the section 27A6, that's going to appeal as well at the end of the year. And we're waiting a decision from Court of Appeal on section 20B. It's exciting times in the legal world in block management.
There are indeed. So with that, I'd like to thank you hugely, Cass, for giving up your time, expertise, and insights and sharing them with the audience. For the audience, thank you so much for giving up your time. I appreciate that. It's a warm and sunny day, but hopefully this has enlivened you for the rest of it. If you'd like to keep up to date with any of our webinars or publications, please follow us on all good social media channels. You're going to receive a follow-up email with various guides, including about the Companies Act and corporate law matters, and the EWS one guide that was written largely by Cass, I suspect. And if you could please just take 10 seconds at the end to provide feedback on this format, it would be hugely well received, and we'd be really grateful. So thank you. Um, get in touch if you have any feedback, any thoughts. And other than that, I wish you all a wonderful Thursday. Thank you so much.
Take care.
Bye.